Welcome to this presentation covering Chapter 5 of our textbook. This actually will be a series of presentations, so be sure to look out for the other lectures on Chapter 5. Let's go ahead and get started. Chapter 5, as you know, covers pleadings. Most specifically, we're going to talk about the complaint, which is the first document that gets filed in a lawsuit in federal court. Let's first of all consider the topic of pleadings. Many documents get filed in court, and some of them are pleadings, and some of them are something different than pleadings. I'm going to talk about kind of three buckets that we think about when we think about pleading, or excuse me, we think about papers that are filed incident to a lawsuit. The first are pleadings, and they are typically the most important documents, and they're also typically the first documents that are filed in the case. Let's look at the definition that we have. We have this definition: formal written documents filed by parties to the litigation to either start or respond to the lawsuit. And we have two main ones: the complaint, which is what we're going to talk about right now, and the answer, which we definitely will talk about in a while. These are the two main pleadings, but we'll see that there are other pleadings as well as we go forward. And so we have certain key terms: formal written parties respond or start litigation. Other documents that we file fit into other buckets. For example, we have the bucket called motions. Motions and pleadings can be difficult to distinguish in some people's minds, but in a way it's really easy because in federal court, let me just go ahead and do this for a second. I'm going to end this presentation and I'm going to go into our federal rules of civil procedure. I like the Cornell one. That's usually the top one. So law.cornell.edu. You certainly can get them in other places as well. And we're going to get to the list of pleadings. We'll go down to Rule 7. And this gives you the names of the pleadings. Anything that isn't one of these 7 named documents isn't a pleading. It doesn't matter how important it is, how cool it is, how awesome it is. If it's not a complaint or an answer or a third-party complaint or a reply, it's not a pleading. And so keep those things in mind. We have a list. If it's not one of these things, it's not going to be a pleading. In most cases, it's going to be a motion. So let's go back to our document here. And so let's compare for a second the differences between a pleading and a motion. Well, a motion usually is in writing. But you can make motions in open court. You cannot make pleadings in open court. But certainly the more common, or at least the way we think of as being more common, is a motion that is actually filed. Most motions that are filed by parties. So that's another characteristic that is similar between a motion and a pleading. You could call a motion formal, but as I say, they sometimes can be oral, so they aren't necessarily as formal as pleadings. So I would say there's a little bit of a distinction here. But the big distinction is that a motion doesn't start or respond to the lawsuit. Typically, a motion is a request that one of the parties to the lawsuit is making to the court to do something that relates to the lawsuit, certainly, but it doesn't actually respond to or address the underlying bases of the lawsuit. And so this is the primary area of differences. Let me put that in a circle because as I'm saying, there's the differences. So this is the main idea when we think about pleadings, that we want to distinguish it from motions. There's a third bucket of documents that are routinely prepared incident to litigation. That would be discovery documents. As you can tell by the name, discovery documents have to do with, discovery. So it's a little bit of a different category of stuff than we have with pleadings. Hopefully that is helping you make sense of the distinction between motions, pleadings, and discovery documents. As I said before, we have two documents that are really, in most cases, the main pleadings that are filed, sometimes the only pleadings that are filed. We have the complaint, and of course the complaint is filed by the plaintiff, and we can see in the word complaint the beginning of the word plaintiff. And the name itself makes a lot of sense because, after all, who has the complaint? The plaintiff. The plaintiff is using the complaint to complain to the court about the defendant, right? So the name itself makes a lot of sense. The document that the defendant files also makes a lot of sense. We call that an answer. And after all, what is an answer? Well, it's responding to the complaint, typically disputing some of the facts or at least legal theories that we find in the complaint. So it is answering, responding to, contradicting in most cases, the allegations or the claims in the complaint. It answers them. Now, as you likely know, there are different names for this in state court. I'm always a little bit concerned about providing the state court names because as soon as I give them, there's going to be somebody who remembers that and doesn't remember the federal court names. But I'm going to believe in you and go ahead and provide you the names. In Texas state court, we call the equivalent document to the complaint, we call it a petition. Don't call it petition in this course. I'm not going to ask you that question because I don't want to throw you. That's what we call it in Texas state court. And this name also makes a lot of sense because when the plaintiff is filing the first document, he is petitioning the court. What is a petition? A petition is a request. So he is asking the court to give him something. Obviously, you don't file a lawsuit just because you're bored one day. You want to get something out of it, so you are petitioning the court. You are requesting something from the court. So you can see how this term also makes sense. It's kind of looking at the document a little differently. In the complaint, the term itself is focusing upon our beef, our grievance, our dispute. In the petition, we're focusing on what's going to solve our problem. But at the end of the day, both the complaint and the petition are going to have a section that talks about the beef, and is also going to talk about how the problem can be solved. So they really are the same document in terms of the content, even though the name is different. There's a little bit of history about the name differences that might shed even a little bit more light on that. And that is, as you probably have heard in many other courses, we have two legal systems within our kind of umbrella legal system historically. One is our courts at law, and the other is our courts at equity. Nowadays, in our legal system, both in the state and the federal level, we've combined courts at law and courts at equity, so the same courtroom is handling both types of disputes. That's not the way it always was. In fact, as early as, say, 1800 or even 1820, common law jurisdictions would have two separate courthouses with two separate ways of looking at disputes, and the plaintiff would have to choose. And if the plaintiff decided to file his lawsuit in a court of law, he would file a complaint. But if he wanted to file his dispute in a court of equity, he'd file a petition. So in our system historically, we had both terms, but we used the terms differently. We used one for equitable situations and one for legal situations. Nowadays, we don't make that distinction. Even if you are suing completely in equity in federal court, you're going to file a document called a complaint. And if you're in Texas state court, even if you're completely suing for legal remedies, you're going to call your document a petition. I find that sometimes knowing the history of how we got to where we are with names can make things make a little bit more sense, or at least make them seem less arbitrary, the differences that we have. Okay, the good news about answers is that we don't have a different name. We use the term answer in federal court, and we use the term answer in state court. There's a few more specifics about the Texas state court terminology that you'll learn when you get to Texas civil litigation, and I'm not going to, again, want to throw information that you don't need at you right now, but there is a little bit more to it than what I'm saying. But for the purpose of our discussion, we call both documents an answer. in whether it's federal court or Texas state court. Now, of course, I'm talking about what we do in Texas state court, but obviously every state could have its own terminology in this area. So, you know, the state of Wyoming might call it a flibberty digit, or who knows what. Certainly petition and complaint and answer, though, are the mainstream terms, and those will get you pretty far. Every court is going to be familiar with those ideas. But of course, if you're practicing a different jurisdiction, you'll want to think through and figure out what those particular names might be for those documents in that particular court. So what are the significance of pleadings? Well, they're hugely, hugely important. They frame the lawsuit. That will be the basis of the court deciding what documents go into evidence, what testimony is allowed, what are the borders of the lawsuit. That the court will look to these documents, the complaint and the answer, to figure that out. So it will establish what gets into evidence and also what is permitted in the discovery process. So they're really important documents. They frame the issue for the case. Not surprisingly, there are rules about how we're going to proceed with our pleadings. And of course, we're going to look to the Federal Rules of Civil Procedure for this course. And if you were in a state court, you'd go to the Texas Rules of Civil Procedure in order to look at the rules there. In addition, of course, to the Federal Rules of Civil Procedure, you'd always want to look at the local rules. Let me just show you where you'd find the local rules, because it's always important to check this. Sometimes it's easy in our courses for us not to kind of constantly be showing this to you because we're not actually filing it. I'm just going to type in local rules. We'll go with Eastern District of Texas this time. They're usually really easy to find. As you see, I just pop this open. I'm going to go to the PDF version so you can see what they're like. And you can see that we have a section on the complaint, the petition, the summons, and the return. We also have a section on the form of pleadings and upon the signing of pleadings, motions, and other documents, and on filing of answers. I'm just going to quickly scan through this so you can kind of see what we have here. See if there's anything that jumps out at me. There's some information about the civil cover sheet. We'll talk about this later on in our presentation. Then we see we have rules about how we're going to file our pleadings in the Eastern District. And of course, geographically, Collin County is in the Eastern District, so this is our place that we focus on. We also, though, do cover the Northern District of Texas, which is where Dallas County is located. So it's very common in Collin County for practices to include both Eastern District stuff and Northern District stuff. So you can see we have to electronically file documents in the Eastern District. That's also true in the Northern District. Of course, the process that you use can vary from jurisdiction to jurisdiction. And there's information about signatures. How do you actually sign the document? Because as we know, under Rule 11, the documents have to be signed. Well, how do you sign an electronic document? Well, this gives you some information about that. We're up to pleadings allowed. You may see that the numbering here tracks with the numbering of the Federal Rules of Civil Procedure. You can see Rule 7, pleadings allowed, form of motions and other papers. And we see here local rule CV 7, pleadings allowed, form of motions and other documents. Many local rules are set up this way. It's certainly handy when they do make the local rules track with the Federal Rules of Civil Procedure. To make sure that you're in good shape from that perspective. I'm not going to spend any more time with it. It's always important before you file something that you make sure that you're complying with both the local rules and the Federal Rules of Civil Procedure. Now I'm going to go back to our core document. Another thing that's important in addition to the federal civil procedure and local rules is to make sure that you are filing documents the way that the particular judge who will be hearing your case will want to hear it. Now, of course, you won't know what judge you're going to get in most of the time when you're filing your complaint, so you cannot tailor it to a particular judge. It may be, though, that in the particular division that you're in, all of the judges have preferences about style. You are going to know what division you're going to be in because of the geographic county in which you're located. Let me just show you for a second how that works. Here we go. Let's go to the Eastern District of Texas. Go to the map. This looks like a good one. Here we go. So we are in the Sherman Division. We are right here. This is Collin County. And you can see we have Denton County right here. And so we know that the Sherman Division judges will be hearing our case. So we don't need to follow what the Texarkana Division judges think. Sometimes the judges in a particular division will have particular preferences. I mean, it's not surprising. They work closely together. It wouldn't be surprising that they have a similar style. But you don't know when you're filing your complaint which particular of the Sherman Division judges will be hearing your case. Now, when you're filing your answer, of course, you will know at that point in time, and so you'll be able to customize your document to meet that particular judge's expectations. So let's talk about the complaint. What is a complaint? Well, it's a document filed by the aggrieved party, and when you see aggrieved party, it's the party with the grievance. You can see the word grievance hiding out here. And if you have a grievance, another word for that would be a beef, a dispute, a problem, a complaint. And so when we say aggrieved party, another term for that would be the plaintiff. And again, it commences or begins the lawsuit. In fact, prior to the filing of the complaint, the court system has no idea that there is even a dispute. This is the first inclination that it has that there's even a dispute between these particular parties. Up until that point, there may have been lots of angry emails and letters and telephone calls and lots of lawyer and paralegal time consumed in this matter, but in the vast majority of times, the court hasn't gotten involved until the complaint is filed. So let's consider what the complaint is about and what are its requirements. So as I said before, the function of it is to initiate or to begin the lawsuit. That's, of course, what the plaintiff is trying to make sure happens. But there is a duty on the plaintiff, and that is also to give the defendant fair notice so that he knows or she knows what he or she needs to do to respond to the allegations. Obviously, it wouldn't be very fair if I could sue somebody and say, I'm suing you. You'll find out on the day of trial what I'm suing you about. Well, how can he prepare for it under those circumstances? That wouldn't be a very fair system, and that's not what the system is that we have. The defendant is entitled to know why he is being sued. That will tell you in most cases it's not rocket science to figure out why you're being sued. It's usually pretty obvious. Usually people don't have 50 different areas of dispute with somebody. So if Bob is suing you and you were in a car accident with Bob 10 days ago, you know why Bob is suing. You may not know the specifics or what his legal theories are, but you know what the subject of the lawsuit is. Let's look at the requirements for the complaint. What has to be in this document? Well, there has to be a caption, and that we'll talk at length about, but that's going to be on the first page. It's actually going to be at the beginning of the document. This caption is kind of a magical thing. We're going to use this caption in some situations throughout the litigation, but we're definitely going to use it throughout the trial court stage of the matter. This happens to be the case even sometimes when there's typos in the document, that the caption is not necessarily changed. There's lots of reasons for that, some commonsensical ones. One is that it makes the case easier to file, because if the documents all look the same in the style, it makes it less likely that there will be errors in the document being filed. So the plaintiff kind of gets to pick kind of how the document is going to be set up. If there's more than one plaintiff in the case or more than one defendant in the case, that plaintiff picks the order of those names for whatever reason that he or she might have. In addition, the paragraphs of the body of the complaint, in other words, the stuff underneath the caption, have to be numbered. We're going to put a number in front of all the paragraphs. We'll see why that we need to have that when we get to the section on the answer. But it sure makes it easier, because if you are having a concern about paragraph 47, it's nice to be able to say paragraph 47, not have to count from the beginning. And sometimes if you don't have numbered paragraphs, it's hard to tell, where one paragraph ends and another paragraph begins. And so by numbering it, it allows there to be an easier discussion about, well, I'm talking about this paragraph. Oh, I thought you were talking about that paragraph. Oh, no, I'm talking about this paragraph. Well, if you number them, you resolve that issue. Now, of course, most complaints don't have 47 paragraphs, but there's a fair number of complaints that have, sometimes over 100 paragraphs. That's not an astonishing thing at all. So remember to number your paragraphs, whether it's a short complaint or a long complaint. We'll also need to have a signature block, and this is for either the attorney to sign if the complainant is represented by an attorney, or if he or she is not represented, then the unrepresented party, whom we call, there's two terms for it, we can call the person pro se or pro per. Either one is completely correct. You'll hear them used pretty interchangeably. So this is referring to someone who doesn't have an attorney. An attorney who is representing himself is also called pro se. So another thing that you'll hear is you'll hear some of those people say who are pro se, I'm my own attorney. You may say, well, gosh, you didn't go to law school. How can you be an attorney? Well, you can always be your own attorney. It's not necessarily you go to law school to be your own attorney. What that person is really saying is, I'm going to function as my attorney for the purpose of this lawsuit. And that's perfectly appropriate. Nothing in the world wrong with that. So there needs to be at the end, again, we talked about what's at the beginning, the caption. At the very end, there's going to be the signature block where the person signs the document, either the attorney, or if the attorney is not involved, then the person who was the plaintiff in this case. There will also need to be in this signature block information about how the court and the other parties can contact the plaintiff or the plaintiff's attorney. And the particulars of that information will be covered in the rules of procedure. There will also need to be an attorney bar number if an attorney is representing the party. Now you may think, not illogically, that the attorney must have to use their federal court bar number or their Northern District of Texas bar number in this area. There are some jurisdictions who do have such a system, and in fact there is a bar number associated with your various federal court bars that you might be a member of. But typically, at least in Texas, the procedure is to list your state bar number, even though you're not actually required to be a member of the state bar. In fact, it would be perfectly fine, and it's not at all uncommon to see people who are not members of the Texas State Bar practiced in Texas federal courts. You don't have to be a member of the Texas State Bar to practice in Texas federal courts. You do have to be a member of some state bar, but it doesn't have to be Texas. But anyway, the practice in Texas federal courts is to list your state bar number. I think the reason for that is that if somebody does something they ought not, we want it to be easy for anyone to report that bad behavior to the relevant state bar association. And that's really the membership that attorneys really care about, because if you aren't a member of a state bar, you can't be a member of the federal bar. So that's an important relationship that every attorney wants to maintain, their relationship with their state bar. And so that's kind of the important kind of disclosure aspect to that number. Let me just show you how you go about, just in case you're ever curious. Let's say you wanted to find out somebody's state bar number. Let's just go ahead and do that for a second. So I'm going to go to texasbar.com. That's our Texas Bar Association. Recently, the Texas Bar has kind of moved some things around a little bit here. I'm going to go to I'll just search myself. So I'm going to add Cynthia River. And I'm going to submit. And here I am. And you will be able to see my bar number. Here's my bar number right here. So I could look that up. When I joined the bar, I was not married yet. I had a maiden name of Ferris. Let's say somebody was concerned about something I did there, they could pull me up with my maiden name. So that's an example. You can pull up anyone that you want to who's a member of the state bar. Let me just randomly, let's say that somebody has filed a case in state court. Let me think of somebody. I'm just going to make up a name. We'll say Bob Herefordshire Smith. Hopefully there's no one with this name. And I punch his name in, and guess what? There's no one in this category. So it lets me know that if somebody has filed a paper saying he's Bob Herefordshire Smith, I'm probably going to be a little bit suspicious. Maybe I'm going to remove Bob just to make sure maybe his legal name is Robert or John or something. Oh, not pulling anything up. Well, let's say I have a bar number. I have, he's entered his bar number as 000000001. Let's see, submit. That actually is. Did not realize that the Chief Justice Supreme Court has bar number 001. Interesting. Okay. So if he were to file a document in court, he would actually use this bar number. So I was expecting an error message here, but let me pick one that maybe we'll get an error message on. I'm going to make it submit. Oh, I guess I typed in too many digits there. 1, 2, 3, 4. Nope, that's not anybody. So again, those would be things that would make me immediately suspicious about what's going on. Is this person really a member of the Texas State Bar or not? Other requirements obviously can vary depending upon the jurisdiction. Of course, in this course, we're going to focus on the rules in federal courts in the state of Texas, but because federal courts, you can join lots of them, it's much easier to join a federal court than it is another state bar. It's pretty common, especially for attorneys who routinely practice in federal court, to be members of multiple federal courts. And so it's more common under those circumstances to be for the paralegals and legal secretaries to be involved in knowing lots of different local rules. So we're going to show you the Texas common rules, but just be aware that just because we do it in Texas this way doesn't necessarily mean other jurisdictions would do it that way. One thing I think that was surprising for me when I started practicing is that I had thought everything was going to be on legal size paper. I mean, after all, that's where the term came from, right? And I suppose once upon a time, legal documents were filed on legal size paper. In most courts nowadays, though, it's just 8.5 by 11 paper, and it's just good old-fashioned normal paper. It doesn't have to be lined. It doesn't have to be onion skin. It's just boring normal paper. And in fact, since we have e-filing, you're not actually even submitting any paper anymore. Usually the pages are going to be numbered at the bottom in some kind of footer, and oftentimes there will be requirements as to what identifying information has to be in the footer. Many times there will be required that you put the name of the document, possibly some abbreviation of the style of the document, possibly the court case number for that document. things along those lines. Typically, documents are going to be double-spaced in the body of the document. This allows it to be easily read. There are some exceptions. For example, the signature block isn't going to be double-spaced if you're using blocked quotations, again, according to Blue Book rules. This is not a class that we're going to focus on Blue Book rules, but as you are preparing documents, you always ought to consider the formatting rules that we use in the law. And you'll want at least a 12-point font, and not just at, I mean, you want to check the local rules, but 12 points the usual. I think in certain courts 13 or 14 may be required, but in most cases 12 is going to be just perfect. And in fact, I would probably use 12 unless 13 or 14 is required as my default if the rules don't specify otherwise. Okay, so now we're going to talk about what are the things we need in our complaint. And we can see we have 4 items here. I'm going to transfer, let me just flip here. I'm going to transfer and call this item 1, the caption. And now I'm going to call this 2, 3, 4, and 5. Actually, I'm going to flip back here. I'm going to call this 5. So these are the bookends. We start with 1, we end with 5, and then we have 2, 3, and 4. We need a short, plain statement of the grounds for subject matter jurisdiction. Typically, after you've introduced the name of the parties, which in some respects, the naming of the parties is an introduction to the whole issue of jurisdiction, especially when we're in federal court. People usually put the jurisdictional stuff next. Under the Federal Rules of Civil Procedure, it's not a requirement that it come next, but it is a very common place for it to appear. Let's go over and flip on to the local, let me see. Well, actually, let's wait for a second. We'll do that in just a moment. Why do people put the jurisdictional section early in the complaint? I suppose it's to kind of get that somewhat boring, mundane material out of the way and then to get to the heart of the lawsuit. Another reason to put it first is that's probably what the court is most interested in. The court is thinking to itself, is this really my case? Is this the type of case I'm supposed to handle? This is the section that addresses the court's primary interest. Hey, was this lawsuit filed in the right place? So it's a threshold issue that needs to be resolved. It makes sense that you resolve that issue, and then you start talking about the particular facts of the case after you've proven that you have filed your lawsuit in the correct court. Then you're going to state your facts. What happened? And this is typically going to be in a storytelling kind of mode. It's appropriate to use some advocacy here. It's appropriate to be involved in persuasive writing in this section. It's pretty common for people to use a combination of storytelling and also the presentation of causes of action or legal theories. And we'll see in federal court you don't have to use magical words. You don't have to actually provide your cause of action, but most attorneys choose to do so. It can be important strategically, and it's certainly hard to see any way that it would be a bad idea. So that oftentimes comes next. And then you're going to have your demand for relief. This is sometimes called a prayer for relief. This was a surprise to me too when I was in law school. I'm like, praying? Why are we praying in a document we're filing in court? Isn't that a religious thing? Well, certainly in everyday conversation, when we talk about prayers or praying, we mean it in a religious connotation. When we pray, the idea is we're communicating to God. When we make a prayer, we are engaging in conversation with God. But historically, the term pray or prayer had a broader meaning than communication with God. It also meant beseeching or requesting somebody who was in a position of power. So it's not sacrilegious to say, I pray you, judge, that you would grant this particular request. You aren't saying you think the judge is God, but you are making a request. So you will oftentimes hear this referred to as the prayer for relief. Again, it's not sacrilegious. It's in fact not religious at all. It's just a way of saying I'm requesting relief. Another fairly common term for it is to say it's a demand for relief. This doesn't sound very polite, does it? I'm demanding relief. But after all, you are in the role of the complainant. You are the plaintiff. You are filing the complaint. And so even though it sounds a little rude to say, I demand relief, it really doesn't come across that way. It's just a term of art. It doesn't offend anyone when you say that. Then we have a demand for a jury. This is called a jury demand. It can also be a jury request. Again, it doesn't have a negative connotation. It doesn't sound like you're being rude if you use these terms. I'm not including this in the list. This is not one of the items because you don't have to request a jury. If the plaintiff doesn't want a jury, he's not going to request it. If the defendant doesn't want a jury, he's not going to request it. And there won't be a jury trial. If we don't have a jury trial, it's called a bench trial. And the term bench in this context is referring to where the judge sits. The historical French term for this is banc. For the first several hundred years of our court system, at least in its current iteration, the language in the court was not English and it was not Latin, it was French. After William the Conqueror, the Norman, the Frenchman, invaded England and took it over, the language of court and the language of the courts was French. And so this was the term for the judge's position. And so you can see how over time it evolved into bench. Judges really don't sit on benches. That doesn't sound very comfortable, does it? They have very comfortable chairs. Don't worry about them. They're going to be fine. But that's why we call it the bench where the judge sits. So if we say we have a bench trial, the trier of fact is not a jury. In fact, there will be no jury. There will just be a judge. If either the plaintiff or the defendant wishes to have a jury, in the vast majority of cases, they are entitled to do so, but they have to request it early on, and they usually have to pay a small fee to cover the expense of the jury, to be honest with you. There are a few circumstances in which even if the plaintiff or the defendant want a jury, they don't get it, but we're not going to focus on that particular situation yet. So this is no jury. Since we don't have to have a jury, we don't have to have a jury demand, and so that's why it's not one of the 5 things you have to have in a complaint. But the vast majority of plaintiffs want a jury trial. And so I think the average plaintiff attorney would say, even though it's not technically a requirement, it might as well be a requirement because we always want one. And so we would consider it virtually always a requirement. Let's look at some customary pleading practices. Well, typically, litigants, in fact, I wouldn't say just typically, I'd say always, the litigant refers to the court in the third person. So the litigants, be it the plaintiff or the defendant, wouldn't say, you need to do this, or referring to the court. It would say the court. The court does this, the court does that. If it please the court. The court should do da-da-da, the court should do da-da-da. It would be considered impolite to refer to the court by a you or personal pronoun. Impolite and not sufficiently formal for the court system. Even in actual court, when you are face-to-face, litigants don't refer to the court as you or your. You can refer to the court as your honor, but you can't say, hey, you judge. That would be considered impolite. Litigants always capitalize the word court when they are referring to the court in which they are in front of right then. It is, if they're referring to another court, then they would use a lowercase letter. It's kind of like a proper name in this context. And so when you say the court, capital C, everyone knows you're referring to the court that's hearing this particular case. Another thing to keep in mind is that the word judgment in English can be spelled 2 different ways. We can have it with it, we always have this E, but we can have this E here, or this E can be omitted in everyday English use of the word judgment. But in American English, usually this first E is omitted even in everyday conversations, and definitely in legal writing we never use this. It really would be a typo to include this E right here. So keep that in mind. Don't put an E here. It looks a little weird having all those consonants together, but that is in fact correct. Litigants say pleaded instead of pled for the past tense of to plead. This is correct, but it's not. I don't want to blow it out of proportion and make it seem like it's a horrible crime if you were to ever say pled. But pleaded is the preferred term. So we would say the defendant pleaded not guilty to the crime, and so saying the defendant pled not guilty. And obviously you're always going to want to use the blue book when you're citing material. And if you're in a Texas federal court, you'd also want to use the green book as well, because the judges there will have typically grown up, quote unquote, as an attorney in the state of Texas, and they are used to the green book as well as the blue book. If you're in other jurisdictions, say in Oklahoma federal court, then obviously all you have to be concerned about is the blue book. In this course, we're not going to be talking about the blue book. You aren't required to have a blue book, so don't worry about getting a copy of it or becoming familiar with it. That's beyond the scope of this particular class. Okay, well, let's talk about the caption. As I said before, it's the heading. It's kind of the name of the document, the title of the document. Title's not the right term for it, because we will have a title, but it is what is the identifier of this particular matter. And it has several parts. We're going to identify the name of the court. Now here we're not talking about the name of the judge. We're not even really talking about the court number, although that will eventually become part of it. We'll also have the case number. Now we won't have the case number when we're filing our complaint because we don't know which court it will be assigned to. So we'll have a blank there that will be added, and going forward we'll have both the court number and the case number to add to the filing. And then we'll have the title of the case. The style of the case is the most common term for it. And that is the names of the parties. Typically it's going to be separated with a V standing for versus. The original complaint, the first copy of it, that is submitted has to identify all the names of the parties. So you might have a style that goes on for more than one page. I mean, if you have 20 people suing 20 other people, it may not all fit on a single page. That's okay. Probably subsequent pleadings, you're going to only have that first name from each side. So if you had a list of, say, 1 through 20 people versus 1 through 20 people, you are just going forward use this name and this name. And again, you just pick the first name on both lists. It's kind of an arbitrary choice. You know, the plaintiff gets to pick the order. I don't think a lot of thought typically goes into it, but maybe a little bit of thought. And then you're going to say afterwards et al, which is short for et alia, which means and others. Et means and that's Latin, but you probably know in French, et is pronounced a, and that means and alia means others. And that's basically meaning I'm not providing the full list, but that takes up too much space. I'm just going to say et al. You can look it up on the original document if you want to see all the names. So underneath the caption, we're also going to have the title of the document. And you're typically going to start with who wrote the document. Plaintiffs, or defendants. And if the plaintiffs, if they're a diverse group, meaning they maybe have different attorneys and maybe not all the plaintiffs are joining on this particular motion or this particular document, then you would list the plaintiffs who are participating in that, and similarly with defendants. And then the version of the document. So if it's the first of these documents, if it's the first time that you file this, you're going to say original. So it might be plaintiff's original complaint. And then that's the first document that's filed. And then a few days later, the plaintiffs decide, well, you know, we want to change our original complaint. Well, then we'd file something called plaintiff's first amended complaint. Then a few days later, we decide, well, we're not happy with that one either. So then we file plaintiff's second amended complaint. Let's say at some point we decide, well, we don't want to rewrite the whole gosh darn complaint. We just want to add stuff to it. Then we'd say plaintiff's first supplemental complaint. This wouldn't replace the current version of the complaint we're using. It would just add to it. So now we'd have two documents that function in combination as the complaint. So remember the three-part naming convention. You ought to have all three parts in every document that you file with the court. And here's an example of a caption. And you can see we have the court up here. This is not where you see the court in a Texas state court matter. So if you've been used to dealing with Texas state court matters, this is a different paradigm. So you can see we know it's in federal court because it says the U.S. District Court. We know it's in the Eastern District, and we even know which division it's in. You want to list all three pieces of that information. Now, not every federal district is going to have separate divisions. Some just have one division. If it just has one division, you wouldn't include this information in here at all. But if divisions exist, you would definitely want to list that. You'll have the plaintiff up here. In this case, the names are capitalized. They don't have to be, although obviously you capitalize the first letter of each name. You may want to look for local practices or local rules in this area, but there's no global requirement they be capitalized. Typically, there's going to be a comma here. Then you're going to indent plaintiff after you've listed all of your plaintiffs. Perhaps 2 tabs or 1 tab. You're going to capitalize the P in plaintiff. If you have more than one plaintiff, you're obviously going to put an S here, and you're going to put a comma. Then you're going to, typically people put the lowercase v with a period flush up against here. And then you list all of your defendants. If you've capitalized your plaintiff's names, you're going to capitalize your defendant names. You're going to list all of them. You're going to indent defendant as much as you indented plaintiff, so this is going to line up nicely. And obviously if you have more than one defendant, then you'll say defendants. You're going to end with a period here. I don't know why. I guess it's just to show, hey, I'm done. If it's a long list, maybe it won't be necessarily obvious. In the middle here, it's pretty common to use section symbols to separate it. Now, let me show you how to make section signals. Let me, so I'm going to go in, let's see. It's a new computer, so I don't necessarily, here we go. Use kind of a big font here. So I'm going to go to Insert. I'm going to go to Symbol. And because it's a new computer, it does not automatically populate here, so I'm going to go to More Symbols. And then I'm going to look and find my section symbol. I'm going to go to the top. You will find very quickly that, here we go, section symbol, so I'm going to put it there. I hit Insert, and there it is, right? Then I would go to the next line, symbol. Now it'll be right here. One thing to watch out for is sometimes you can have your symbols in a different font. I'm not sure how that happens, but accidentally I might have it in a different font, and now you can see it doesn't look right. So be sure that you globally make sure that all of your fonts are correct going down here. And so that's a little bit of a pointer how to do that. Let's go back to our document. And so we'll make these section symbols. We'll want it to be right down the middle. The way to do this, though, is not to center, because we don't want to center this stuff. So we're going to tab over to the approximate middle. So tab, 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 then make our section symbol. Tab, 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 make our section symbol. We won't want there to be a big space here, and we'll want these to line up. So you will not want to use the space bar to line them up, because that will not result. There'll be a little bit of a wiggle to this line. You don't want that. You want to use the tab button to do that. And you want them equally distant from each other, and you don't want to have gaps here. I mean, you have a little bit of a gap here, but you wouldn't want there to be a significant gap here. By the way, this should be capitalized here. It's not unusual for this to be in bold. That's fine, or it doesn't have to be. You'll have your civil action number here, and again, you'll leave this blank because you won't know at this point whether it's going to be what the case number is going to be, and so this will be something that you will know going forward. But for the complaint, when you're writing it, you won't know what it is. And then we say jury here in the Eastern District. Other courts may say jury demand. We say jury, but it's the same idea. That's what we're pointing out here. This is just making it easy for the court to keep track of whether this is going to be a jury trial or not. And then you can see we have the name of the case. You can see it follows that pattern, those 3 items we have to have. We know who filed it, plaintiffs. In this case, we know who the plaintiff is. There's only one plaintiff, so it's Buford T. Justice. So it's apostrophe S because there's only one. Original, so this is the first one, the original. And then we have complaint. In many cases, this will be what goes in the footer in your document. Okay, so let's talk about some things about parties. Because of course, the caption is all about the parties. In this case, we have 2, Buford T. Justice and Bert D. Bandit. Sometimes there can be issues about who ought to be sued or how they ought to be sued. And one way to think about that topic is as we're drafting the caption. So generally, the named plaintiff should be the real party in interest. This is a term of art, meaning, actually, let me pause here for a second. I'm going to flip on over. I said I would do this earlier and then I forgot about it. I apologize. Let's go to our rules. Commencing an action, Rule 3, a civil action is commenced by filing a complaint with the court. And then we came down here, and these are the names of the documents that can be pleadings. We'll talk about motions at a later time. Let's go down to Rule 10, form of pleadings. And here we have some of the requirements. And here we've been talking about captions. Let's pause for a second and talk a little bit more about captions. So we have Rule 10, caption, names of parties. Every pleading must have a caption with the court's name. Going back here. When they say court's name, they're talking about this in the U.S. District Court for the Eastern District of Texas, Sherman Division. A title, and that's here, plaintiff's original complaint. A file number. We don't have that here yet, but this is what will be stamped by the clerk, electronically stamped in the case of electronic filing, right here. A Rule 7A designation, okay? Again, let's just look at the list of names we can see here. So you've got to name it one of these things. So we're calling it, our document is a complaint. So that's where we see, that's how we are complying with that. Oops, let me go back to 10 now. The title of the complaint must name all of the parties. The title of other pleadings, after naming the first party on each side, may generally refer to other parties. The title of the complaint must name all, I'm sorry, I misspoke. The title of the complaint must name all the parties. Again, that's that first caption. The title of other pleadings, after naming the first party of each side, may refer generally to the other party. So that's what you know, the first complaint, you have to list all 20 people that are suing, but going forward, you have to list the first one. So those are the rules about about the caption. Okay, so we have that real party and interest. Sometimes we will see that, especially in certain state courts, that the name of the party who is on the pleading is not necessarily the party who will benefit by winning the lawsuit, or so that's the real party interest, the party who's actually going to benefit. In federal court, though, you aren't going to list necessarily the guardian ad litem. You aren't going to stick with the real party interest, the person who's going to get the money at the end. Okay, so let's look at some particular rules that flow from this. If the party is a competent individual adult, use the name of that person. Okay, let's look at some terms here. Competent can throw people a little bit. You can say, well, gosh, Bob isn't that smart. He's not that coordinated. He's kind of an idiot, to be honest with you. I mean, he's an adult, you know, he's over the age of 18, but gosh, I wouldn't call him competent. Well, the standard for competency for being able to sue and be sued is very, very low. Even if Bob has some diminishment in intellectual abilities, it's very, very likely he is competent under the law. So don't let this term fool you into thinking it's a high standard. It's a very, very low standard. So obviously, typically when you're suing somebody, you're going to sue them with their full name. And we saw that in our complaint here. Look, we have Buford T. Justice's full name, and we have Bert D. Bandit here. So that's consistent with that. If the party is a sole proprietorship, you use the name of the sole proprietor. What is a sole proprietorship? Well, that is a business that hasn't been incorporated, or it doesn't have any legal identity apart from its single owner, its sole proprietor. Many times sole proprietorships have catchier names than that. So let's say this business is owned by Bob Smith, and Bob Smith has a bakery called Bob's Bodacious Bakery. Well, that would be his doing business as his DBA name is Bob's Bodacious Bakery. But he hasn't not chosen to incorporate his bakery or make it an LLC. It's a sole proprietorship. And so therefore, if you want to sue Bob's Bodacious Bakery, you probably should sue Bob Smith. And you could say Bob Smith, DBA, Bob's Bodacious Bakery if you wanted to. But usually going to actually give the name of the owner, so the sole proprietor. If the party is a general partnership, if the party is the plaintiff that's a general partnership, use the name of the partnership itself. Let's say that this partnership had 4 partners: Smith, Green, Brown, and Lewis. Well, maybe the name of the partnership is just Smith and Brown. Even though Green and Lewis are also owners, name is not part of the, it's just gotten too long of a name to fit comfortably on the letterhead. So into that situation, you would actually just use Smith and Brown, even though Lewis and Green are also owners. When you are suing a partnership as a defendant, and you are just going to try to collect against the partnership, the general partnership itself, then you would sue just that name, in this case Smith and Brown. But if you also want to collect money against the individual, let's say, for example, Lewis is very wealthy, and you don't think that the assets of the general partnership is going to be adequate to satisfy your purposes. So general partnership, so there is personal liability for all members, even to their personal assets, then you'd want to sue the partners individually as defendants. So here we have the general partnership example. So we have Bert T. Bandit and Cletus Snow, a partnership. doing business as 10-4 trucking defendants. So in this case, the plaintiff wants to be able to collect against the partnership, but also collect against the personal assets of Bandit and personal assets of Snow. Obviously, that's the smartest strategy. You're increasing the size of your potential recovery, and so that's a smart idea going forward to do that. So we're still focusing upon suing the real party in interest. Let's talk about a corporation. When the corporation is the plaintiff, it doesn't matter how many shareholders there are. There might just be one, but you cannot sue under the name of the individual shareholder because the corporate formalities have to be followed, and so you actually sue under the name of the corporation. Similarly, you sue under the name of the corporation when you're suing the defendant. If going back to this example, let's say that Bert and Cletus didn't set up their business as a partnership, 10-4 Trucking, but it was 10-4 Trucking Incorporated. Well, Bert and Cletus's personal assets are going to be safe. It's only the assets they've put into this business that are in jeopardy. And so you would just sue 10-4 Trucking Incorporated, and you couldn't sue Bert and Cletus individually in the vast majority of cases. Now, as I say, in the vast majority of cases, there are a couple of situations that are different. One has to do with piercing the corporate veil, and this is when a corporation doesn't follow its corporate formalities. This is a very complex subject, much more complex than we can talk about here. This topic will likely be covered in some detail in LGLA 2311, which is our business organizations class. This is when a corporation doesn't file all the paperwork it needs to and possibly is committing some kind of fraud on its creditors or its customers or something like that. And when the facts are sufficiently egregious, it's possible that the court will allow the corporation to not be treated as a corporation and that the individual shareholders could be subject to personal liability under those circumstances. Sometimes directors and officers can also be sued individually if they personally breached a duty. Again, this wouldn't be a liability they have because they own shares of the stock, but because of their personal responsibility. Okay, so we also could have situations where a business uses that DBA or that doing business as name. And again, we have another example. Buford T. Justice has an entity that is the Authority Appreciation Services. That's a DBA name. As you can see, it's not a corporation or anything like that. Technically, you don't have to list that in your caption, but it's a good idea. It's certainly a typical way of listing that information. There are certain requirements that have to be filed in order to list a DBA. You have to make sure that you have followed all the assumed name rules with respect to that particular DBA. So be sure that you're following those technicalities as a plaintiff before you list something as a DBA, or you can get your hand slapped for not following those technical rules. Again, if a business uses an assumed name, you'll want to sue under the legal name of the entity, but of course you can add the assumed name as a DBA as well. Okay, so we've taught generally that the usual rule is that you are going to sue the real party in interest, but there are a couple of exceptions to that rule. So this would arise when, let's say, an estate is being sued. In this example, we have Wilhelmina Justice. She's passed away, and Buford T. Justice is the executor or possibly the administrator of her estate. He may not even be an heir to her estate. It may be that several people might benefit from her estate, might inherit the estate. They are obviously the real parties in interest at this point. Mrs. Justice has passed away, so she's not going to gain anything from this. And as I say, Buford T. Justice may not be an heir to the estate either. But at this point, the estate has not been settled, and so we do look to the executor or the administrator being the person who sues or can be sued. But keep in mind, there's the understanding, because we have this disclaimer here, that this is not for Buford T. Justice's own pockets. This is simply so that he can represent the interests of the estate. He's the only person that has the power to do so at this time. Another situation that arises is when there's a minor, an incompetent adult who would like to sue. Again, we're talking about from the perspective of plaintiff. So in this situation, we have Junior T. Justice. He's a minor. He's under the age of 18. Well, it's not possible for that person to sue at this time. But let's say he's been in a car accident, he has significant medical bills, and so under those circumstances, perhaps a guardian ad litem will be appointed to represent his interests. In this example, we have Buford T. Justice in that particular role. In Texas state courts, we oftentimes call that next friend. It's kind of an unusual term for that, but that's the term that we have in Texas for that. We could have a general guardian. This would be somebody who has a general responsibility for that person's financial affairs. And again, it could be the minor, but it could also be an incompetent adult, maybe somebody with Alzheimer's or somebody who is in a coma or something along those lines. And then you can have a guardian ad litem who's a guardian only for the purposes of this litigation. So ad litem means for this litigation. Let's talk about the issue of unknown defendants, suing somebody as a John Doe or a Jane Doe. That's a fairly common practice in many state courts, but it is generally not permitted in federal courts. The idea is that the public has a right to know all the facts of the lawsuit. All court actions should be a matter of public record, and so if you're suing John Does, you're not revealing that information, and so generally, you're not allowed to use those types of names in federal courts. But there's some exceptions to that rule. If a statute of limitations, for example, is approaching and the plaintiff wants to stop the running of that statutory period, he can file against an unknown defendant in federal court, and that will stop the ticking of that clock. In that filing, he's going to have to state that he doesn't know that person's identity at this time, and that he commits to amending his pleading as soon as he learns of that identity of that person. In that case, it's very likely that the court will allow that date to relate back to the date of the original lawsuit. It's not an automatic thing, but that's the usual path, so that even though, say it was only 3 days away from the statutory period expiring and the plaintiff wasn't able to figure out who that person is he wanted to sue until a year later, well, statutory period would have expired then. But if it relates back to the date that he filed his John Doe lawsuit, well, then the statutory period is still okay for that particular claim. We'll talk about class actions in our next presentation as we talk more about parties. Thank you for your attention and have a wonderful day.